So our speaker today is Alan Oppenheimer. Alan is an engineer by trade, graduating from MIT, then joining Apple to work on their new Macintosh computer and their networking system. In 1995, he moved to Ashland and founded Open Door Networks, an internet provider and utility company. He co-founded Art Authority in 2008, first as the award-winning AppLine and then as the Fine Art Printing Company. He is currently the chief wizard, and I must say that is career goals title, if I may inject, at 1000 Museums, Art Authority, handling everything from retail sales and museum operations to image acquisition and rights clearance. Please give a warm welcome to Alan.
Thank you. Since we're on the copycat versions in this state as well, which probably came first. So this talk is copyright, and it's about copyright. So a little bit about me and why I can give this talk. So of Art Authority LLC, which started with the Art Authority line of apps that you may be familiar with back when the iPhone and iPad were first coming out, and that really took off. Then a bunch of real art authorities found us, and we ultimately acquired the company 1000 Museums, which had started about the same time, back in about 2008, and they pioneered licensed archival print products for museums, businesses, art lovers worldwide. And they and we are all about getting music when museums thrive, and we all thrive. I am not an artist, but it turns out my grandmother was an artist down in Baltimore. And I am not a lawyer, even though this talk is on legal things, but both my dad and my grandfather were lawyers, so I was sort of destined to be at the intersection of art and legal, which is where we are today. I have, in the process, learned an incredible amount about copyright, and as you'll see, there's way more to learn. And the generic legal disclaimer, right? 1000 Museums, Art Authority, the company I work for, and myself, we do not provide legal advice, not even close. Okay, so this is not legal advice. If you're ultimately going to want to go there, you probably have a legal counsel you should talk to. So, what is copyright? Copyright, one word, is a type of intellectual property, often called IP. And what it is, I'll get to in a second. What it does is probably the most important works of art. Okay, and its existence is why many works of art exist. Because if you, as a creator, did not have any rights to your creation, and anyone who wanted, once you created it, could do anything you wanted with, that would be a major disincentive to actually create it in the first place. So the U.S. Constitution, okay, and way before that, it goes back to England and probably even before that. This is in the U.S. Constitution, that the Congress has the power to promote the progress of science and useful arts by securing copyright, in this case, patents as well, trademarks. It's all in the U.S. Constitution because the founders knew how important it was for the new country to have innovation in both science and the arts. Okay, it's different from patents, okay, in that it protects the actual expression of a creative or functional work, not the ideas, process, and discovery. That's a patent, okay? A copyright protects the expression, creative expression of ideas, okay? So creators of art and works for us, the public. But just as critical for us, the public, is, as it says in the Constitution, for limited time, okay? Because ultimately, the Constitution, our laws are all about us, And so if you could lock up your work forever, be it a patent or a copyright, that would not serve the public interest either, okay? So the limited time is also as important for us, the public. So what really is a copyright? It is a right to make and sell copies of the work that you have created. That's a copyright. Okay, it also lets you, the creator and copyright owner, create derivative works based on that work. You and only you can take that work and make a sequel or make, a derivative, a derivative work, a different work that's based on the original. And very important for us here, and certainly for my company, 1000 Museums, is it lets you, the copyright holder, authorize others to execute any of your rights, which is a license. Okay, and we'll talk about that. So that is copyright. The main question that appears from museums in general is, I own this work, right? We bought that Rothko. We were deeded that O'Keeffe, okay? Don't I own the copyright? Can't I make copies? My work, I own it. No. That's about the only easy question in copyright. Okay, you're going to see, we're going to get into the book, and you bring it home with you. You do not own the copyright on the book. You own the physical page. Well, not anymore. You own the bits in your phone, okay? But when and if you ever went into a bookstore, which I haven't done in a while, and you bought a book, you would own that physical book. That's it. Okay, you would not be able to, it doesn't matter. Okay, you own that physical work. No one can take that off your walls. Okay, but you cannot make photographs of it. You cannot sell copies of it. You can't sell postcards. You can't sell magnets. You can't do anything with it. Okay, if it's under copyright, and that's a big if that we'll be talking about. Okay, usually when you get a work of art, you don't get the copyright. Okay, but in some cases, you do. You might. Okay, it's between you and the seller or the deeder, right? But if they don't give it to you, you don't get it. Okay, so unless it's specifically, let's say it's in a will, and it says, I will, my art to such and such a museum, then you get the physical work. If it also says end copyright, that's a much bigger deal. That's a much bigger, more than just the work. So an example is George O'Keeffe. Okay, when her, I don't know if it was her estate donated her works all over the place. Okay, and it included the copyright in many cases. So if you have an O'Keeffe, you may own the copyright, but you may not. A lot of it's controlled actually by the, so it's an example, and you just have to ask. You have to ask your legal people, your curators, and they may have to go back to the bequest, and it still may not, they might even have that, so you may have to talk to the art, so you're going to have to ask. But again, so this is the Copyright Act 1976, which is sort of the defining document here in the U.S., okay? And it makes it very clear, transfer of ownership of any material object does not of itself convey any rights to the copyrighted work. So, no. Easy answer, only easy answer. Okay, now, what are the rules and limitations of copyright? This is the opposite. This is complicated. It's ridiculously complicated. I'm not sure anyone knows this. They're copyright lawyers. It's different, in different countries. So I've learned an awful lot about this, way more than I really ever wanted to, okay, but it's important for what we do. So questions depend, for instance, was the work formally published? In the flow chart, and I actually had a flow chart on this slide, but I took it out because it's crazy. Was the work ever formally published? Now for art, which is what we're talking about here, very rarely will an artist publish their work. Now, of course, this happens with certain artists such as Norman Rockwell. His work was published usually in the Saturday Evening Post, okay? But he would go down the left side of the flow chart, okay? But most creative works that we're used to go down the right side. It wasn't published. An interesting exception, which we can talk about, Picasso's Damsels of Avignon, which you may be familiar with, was actually published. And we'll see that got it into the public domain, which is really interesting. Most Picasso's not. In what country was the artist born? In what country did the artist create the work of art? And in what country did the artist die? So there's three questions within in what country, okay? And that makes it even more complicated. Was nude, okay? There used to be all these formal rules. You literally had to put C in circle, copyright date, such and such, and then you had to renew it every 28 years, otherwise it expired. Okay, that doesn't apply anymore, but if it went and expired, you can't unexpire something, okay? And now it's in the public domain, which we'll talk is when did the artist pass away? Okay, that is the key question. And in particular, again, that U.S. 1976 copyright as amended by Mr. Sonny Bono at the respect of Walt Disney Company, which you may or may not remember. Basically, that is where the 70 years in the U.S. and most countries comes in. Next question that we often get. Can I photograph a work of art to create a new copyright to it? Okay, I'm the Louvre. I own the Mona Lisa. It really upsets me that there's so many copies of everyone's just freely copying, making their Mona Lisa. I want to get a copyright so I can control it. Oh, I'm going to take a photograph of it. Okay, this is a new work of art, and I'm going to copyright the photograph. Nice try. You know, people actually tried this. Okay, but the court said no. Okay, because it's a very complicated decision. It took many years, and it's called Bridgman versus Corel. You guys may be familiar with Bridgman. They're an art licensing library. But basically, they lost. That they tried to take pictures and then say it was copyrighted, but the court said, no, there's no creative expression. And that's what copyright is all about. Creative can go up to the Mona Lisa and take a photograph of it. Okay? And there's just nothing to that. So the court said, no, you can't take a photograph of a work of art to get a new copyright to it. Okay, now, interestingly, they also said this only applies to two-dimensional works of art. Three-dimensional work, and you are making a two-dimensional presentation with lighting and, you know, because there's going to be a background, you know, and you're going to have a certain, you know, angle on the thing. So you can do that. Now, whether you can actually copyright a 3D scan, which is a new thing that's coming out, right, a full 3D scan with a reproduction, copyright that, but that's never been tested. So that's an interesting future thing now that we have 3D printers. You know, could you publish online the specs, the 3D printing specs for the David? Don't know. Are there such specs online? I don't know. So always new technology. I'm a technology person, so it's always interesting to see the new technology. Okay, now the concept of fair use is one you may have heard. It's very important to copyright. Just because you, as an artistic creator, have a copyright doesn't mean that you can take your work and lock it away, you know, from the public 100%. Okay? Now, of course, if you've never put it into the public in any way, you've got it in a closet, it's in your closet, no one knows about it, it's one thing. Okay, but once you publicly show creative work in any sense, okay, the public now has certain fair use. So you can't just say, hey, look at this, oh, never mind, forget it, you can't, it never existed. You can't, you know, you can't even tweet that you saw it. You know, fair use says, yes, you can. Okay, so fair use is what it sounds like, older, and it's fair to the public. Okay, that ultimately is the reason that we created copyright, is not to let some creative person just make money, you know, it's to let them, incent them to create the work for all of us. Ultimately, these works are for all of us, any work, any creative item, for all of us, any work, any creative item. So fair to the copyright owner, fair to us. Okay, Copyright Act, again, talks about fair use. It's a very comprehensive law. I don't know how the government ever created it. It doesn't seem to be able to do anything anymore. Okay, but back in 1976, they seem to be good at things. I don't know. It's pages and pages and pages, and it makes sense. I mean, that's the other thing. It sort of makes sense. So fair use says that even if you have a copyright, other people can criticize about your work of art. Very, very important. Okay, but now you got a gray area, right? Gray area where people can claim fair use, you know, and it's like, oh yeah, you know, I had to reproduce that entire book so I could give it out to my class to read. No, it's never fair use, I don't believe. Again, not a lawyer. It's never fair use to copy an entire work, okay, and reproduce it and do stuff with it. Okay, it's also never fair use, I don't believe, to take it and sell it. Okay, copyright is about many things, but it's about profiting from your creation, okay? So fair use, and the bottom bullet there, the effect of the use on the market for the copyrighted work, okay? If what you do causes the copyright owner to lose money they would make otherwise, that's not fair use, especially if you're the one making the money instead, okay? So it also has to do with the nature of the copyrighted work itself. Classic example there is the phone book, if you remember what a phone book was, work to compile a phone book. You can actually copyright it though, okay? But, you know, it's sort of like on the border, so fair use would be, yeah, you can take phone numbers and publish them out of the phone book, you know, any way you want. So, and again, how much of the work is used? So if you're quoting, the classic example is you can quote up to like usually a paragraph even or two of a book, okay, or a newspaper, another newspaper, or a speech by someone, right? You can quote a paragraph or two of a large work, but if the work itself is a poem, okay, 4-line poem, okay, you probably can't quote more than a few words of that poem. So it depends on the percentage of the work, whether it's fair use or not. And, you know, you don't want to get even close to this because one, you want to be fair, and two, you don't want to end up in court. So you just want to understand it and not really push it. Okay, so taking a step back, big picture, what does this mean to people in this room, okay, who are mainly museum people of art, are totally in the public domain, and we'll define public domain in a little bit. Okay, early works, Renaissance, almost all the Impressionists, and again, photos and scans, because you can't get a new copyright just by photographing something. All of these are in the public domain. They are literally owned by everybody. Work can do anything you want with that work of art in terms of copying it. Okay, but once we get into the post-impressionists, such as Matisse, okay, and then the modern, almost all the contemporary, they're still under copyright, and they have to be licensed for most uses. 51, okay, 70 years, right? So 22 less 70 goes back to 52, but it turns out you have to wait to the end of the year. Okay, just a little additional minutia there. So right now, any artist, their work is almost undoubtedly in the public domain, but there are all those exceptions, right? In that flow chart. If they publish something, let's say the year before they died, okay, or even the year they died, okay, and they copyrighted it, okay, now that copyright starts then, renewed the copyright, okay, then in theory that can go on longer. So Kandinsky is an example that almost all Kandinsky's work, I think he died, I think his 70-year death was in 2015, something like that. So I guess that was what, 45? But he did that renewed the copyright, so there are a few Kandinskys still under copyright, but most of them are not. And hopefully you're enjoying the little pictures, images that I came up with here to try and illustrate, for instance, creation, which is what copyright is all about. So here are some examples of artists whose works are or are not still under copyright. So, you know, all the ones you can imagine, Michelangelo, Rembrandt, you know, there's, you know, way back, so I think everyone understands them. Turner, Van Gogh, of course, is probably the absolute favorite one that is totally public domain. And that's why you see all these things popping up with Van Gogh, right? The immersive experience, right? And Starry Nights like all over the place and whatever. So it's sort of interesting, the effect of copyright, you know, causes all this creativity and it causes all this creation, and then when it expires, there's like a rebirth of creativity after that, right? So when it's locked up, you know, you can make this argument, you know, when it's locked up, there's less creativity, right? So the artist, he or she passes away, now the estate, you know, it's in their interest to keep it locked up because they're going to get all the money, and they also can control the creative process, so that's worth a lot. And you can say that they earned it as heirs of the creative force, okay? But ultimately, it tends to actually have a somewhat depressing effect on the overall market and creativity in a lot of cases, certainly not all. There are some artists, estates that really license very widely, and they're really great. There's others that just totally lock it up and go, no, my dad never wanted his stuff to see the light of day, and maybe that's true, okay, and that's their right, and but from my personal perspective, I just love it when some works see as much of the light of day as possible, and then in some ways my favorite day is January 1st for lots of reasons, and assuming I haven't had too much to drink the night before. The fun thing is to find out all the artists whose work just went into the public domain, and now we as 1000 Museums and you as the public, all of a sudden we can do a whole lot more than we did before in terms of creativity and things like that. So what happened with Van Gogh? We just see now, we see those claymation movies, the immersive, that probably wouldn't have happened without it being public domains. That's what the public domain is all about. Okay, and Cassatt, Kandinsky. So the artists, and a perfect example of fair use, okay, are Matisse, Mark Rothko. Picasso is just a classic. There are so many Picassos out there, okay? The Picasso administration in France totally controls those, as is their right. O'Keeffe, we talked about a little bit, and sort of our personal favorite, Wayne Thiebaud, just passed away last year. And if you haven't seen his show, you definitely should. So, but notice over here, I am actually displaying copies of these copyrighted works. How can I do that? Fair use, right? Because what am I doing? I am actually educating all you guys about fair use, okay, and about copyright, right? And about these works of art. I have taken very, very small versions, right? These are not going to commercially affect them. I'm not going to buy a copy of that. Okay, if anything, this fair use usually enhances the market, almost always. And if you read an article, about a Thiebaud show, and here's one of his great works is Boston Cream's my favorite. I don't know if you were at lunch today. I actually took a picture of the perfect. We were going to give them away in our booth, but we didn't get around to that. So anyway, really enhances the market for Thiebaud's work. So. I was very proud of myself for coming up with this example of fair use, to be able to show both the works of art and explain about fair use at the same time. Okay, we talked about public domain. I think you guys sort of understand that, okay? But public domain means quite literally, okay, the copyright to the work is owned by the public. Every single person in this room owns the copyright to every work by Vincent van Gogh. So I hope you guys are happy about that. Go home and tell, your family, I own the copyright to Vincent van Gogh's works, because you do. And so do all 7 billion people on Earth. Okay, in arts and sciences. Okay, and, if that was locked up forever, 99 out of 100 works of art would never be known again, right? They would have been locked up forever and lost. Okay, this way, once a work enters the public domain, you get that extra. Now the whole market can leave, okay? But now we can go back, we can do some research, we can go into libraries. If we can find them, if we can make scans of them, which is big if, now we can bring them back to the public, right? Such and such, my grandfather did this. We can go back, and we can find them and reproduce them, even if that person's grandfather didn't leave the copyright to them, okay? And that's because we, 1000 Museums, own all those copyrights. We are so happy. We own millions of copyrights. Okay, I own them personally too, so that's really great. Okay, how does the work enter the public domain? Okay, so mainly by the copyright expiring in the way we said. Okay, and that's why every January 1st is fun for me, because it's when I own a lot more copyrights. Okay, sometimes an artist, a creator, will put the work in reasons. Okay, such as they don't want to deal with licensing. They want it to go around the world for free. They just want the maximum possible public exposure. They don't care necessarily about the dollars, okay? Or, in some cases, works are not created by copyright. There are a lot of exceptions here, but the big one is if the U.S. government, right, our taxes, assuming you're from the U.S., our taxes paid for already. We're not paying twice, okay? Well, we are. We're paying like 8 times, but we're not paying 9 times. right? In Oregon, we have the state tax, so we federal tax, state tax. If you live in New York City, you pay New York. So you already paid for it 3 or 4 times. You're not going to, you own it, okay? It's in the public domain already, okay? So a lot of WPA, the Work Progress Administration during the Depression, a lot of Dorothea Lange would be one, did work for the government, and those are already always were in the public domain. So a lot of interesting works are.
What's an example of an artist that put their own work in the public domain? What occurs to me is like Keith Haring. You see his stuff just everywhere, and he just died in the 80s.
Okay, so the question was about an example of an artist. Is that all? People may copy it without permission, okay, and he did die a long time ago and may not have, I think he had a will and established a foundation, but so I don't believe that's an example, and I don't know a specific artist that specifically put works into the public domain. In my field now, which is software, okay, you may have heard of open source software. Okay, many different companies think it's in their interest to put their code, their software, their apps, if you will, into the public domain for various reasons. Okay, lots of examples of that. If anyone else does know an artist, who has put their work in the public domain, it's very easy to do. Okay, you can go, Wikipedia is the expert on public domain because Wikipedia is, everything in there has either in the public domain or some what's called a CC license. Okay, they're the experts on public domain, and lots of people would go. So a lot of amateur artists and photographers put their work in the public domain by putting it on Wikipedia. Okay, but I don't know, a museum artist who has actually done that, but there probably are. Someone wants to Google that, you can let us know, but it's a really good question. It certainly can be done. Okay, and so most of this talk and most of the concern is about violating copyright. We want to make sure we don't violate copyright, we get the licenses where needed. There is the opposite though, okay? We don't want people stealing our copyright, we don't want someone stealing it back, okay? And this happens fairly regularly, usually by accident, okay? Where a museum, for instance, will claim copyright, or once in a while a person will claim copyright of a work that was in the public domain, and that's called copy fraud, okay? Okay, and it's a pretty serious problem. It usually happens by accident, but you guys probably know the birthday song, happy birthday to you, okay? There was a group of people who claimed copyright over that, okay? And it took years in court to prove that that work was in the public domain like 100 years ago. And they just snarfed it up and started charging. A lot of movies couldn't have that work in it because they couldn't license it from this foundation or people. So that was copy fraud, and they ended up having to pay a huge settlement. So be careful, in your websites, especially when copyright expires, on January 1, you don't still have that copyright line on there. Like I said, it usually happens in the museum world by accident. Once in a while, we get a museum asking us to reproduce a work of art, and we always put the credit line. They always give us the credit line. We're looking, it's like, wait, that's the Van Gogh, and they're saying copyright such and such a museum. Okay, and it's like, we go back to them and say, you mean well, but we can't print this that way. Yep. Okay, so the question is, I think that you're saying you do put a copyright line even for works in the public domain in some cases? Okay, so she's asking about copywriting the postcard. Okay, now if you take a work of art, of these, okay, and then on the back, for instance, you have your logo, okay, and you may lay it out in a particular way. We have our standard postcards that our museums don't lay out, but then we have custom postcards or note cards, okay. Can you copyright the back, okay? And yes, you can copyright the back. So a credit line, that said, work of art such and such and such a museum, and then you said postcard, copyright our museum, that would be allowed, right? So you can get a copyright on the back of a postcard that you... That's going to be up to you whether you want to put any copyright line at all. I would recommend against putting any copyright line for 2 reasons. Number one, at least 2 reasons. Number one, it takes up space. Okay, in a backup postcard, you're already out of space. And number 2, it's confusing. Okay, even if you say postcard copyright, whatever, it could be misleading copyright over the work, okay? And so I would recommend against that, but it is your creative right to copyright the back of your postcard if you want to. That's another good question. Thank you. Yep. Yes, 100%. But anyone does, right? And we'll have a slide on that in terms of your advantage as the museum owning the work of art. But yes, once it's in the public domain, you own it, your museum owns it, I own it, you can do anything you want with.
And you profit from the sale of items that have that image on it.
You can do anything. You can even mess it up. You can make a derivative work is one thing you can do, right? You can paint a mustache on the Mona Lisa, right? And that, of course, has been done. And then you can copyright your creative expression of painting a mustache on the Mona Lisa at that point. Can't take a photograph of it, no creative expression. But if you take the Mona Lisa, paint a mustache on it, all of a sudden you've made a new creative work from a public domain work, and that's actually copyrightable. Weird. Okay, so this is basically your question. Well, it's a derivative of your question, okay, which is not only can we make items with our work of art that's now in the public domain, okay, but can we license business for a number of our museum partners? They license the images to us even, right? And we love paying royalties back to them in that instance, okay? Because yes, you own the actual work, okay? You can take images, photographs, scans, whatever, and you, for reasons that we're gonna see, okay? And you can license either public domain works or copyrighted works, but to license the copyrighted works, you're just licensing the right to reproduce the image once they have the copyright, okay? So you can't blanket license works under copyright, but you can tell your licensee, okay, yes, you can reproduce this work of art, here's a digital image file, but you have to get the copyright clearance as well, which is another thing we specialize in, which we'll talk about, okay? And one of the advantages of licensing your images, even if they are under copyright or even if they're in the public domain and anyone else can license your images, that is, images of your work, because again, it's not your images, okay? Anyone else can license images of your works, but you have a big advantage, right? You own the physical work of art. No one else does. You're the only one that can say, this is the authorized reproduction of the physical Van Gogh work that is on our wall, the physical Thibaut that's in our lobby, okay? That gives you a big marketing advantage. The image just as much you do, but they can't say, I'm the authorized provider of this work. It's like you see on NBA games, right? Coca-Cola is the authorized soft drink of the NBA, right? So you can have the authorized, Thibaut of your museum. So that's pretty cool. Now, whether you want to license works of art, whether you want to spin up a whole licensing department, some museums do and some museums don't, okay? Some just say, no, we're not going to license our works at all. We just don't want to deal with that. We want people coming in our doors, okay? This is the old-fashioned way, okay? Before there was a thing called the internet, especially before there was something called COVID-19, okay? All you tried to do was get people in your doors, okay? For a while, there you wanted to get people not in your doors. You wanted no one coming in your doors, and you locked your doors, okay? So to not license images at this point is really not fulfilling your mission as a museum, as I understand museum's mission, which is to get the works out, right? So you probably want to run a licensing program or somehow license your images, okay? So many museums spin up their own rights and reproductions, and have lower res things on your website and say, contact us and have contracts. And then we, 1000 Museums, we love that. Makes it easier for us. We also have our own contract. If a museum doesn't want to deal with that, we say, hey, look, we have a standard licensing agreement. We've already written it for you. We've got a % royalty. Here it is. A lot of times they love that. They license their image to us. We make the reproductions. They get the royalties. They get much bigger exposure of the works of art, which is the real point. Okay, win-win. Win-win-win, because of course the public loves it as well. Okay, there are also third-party licensing agencies. Okay, I mentioned Bridgman Art Library, and also another big one here is Art Resource in the United States. Bridgman is in the UK. And they take a bunch of art from a bunch of museums and private collections. They handle, or at least work with you on the digitization agreement with the third parties such as us, okay? We actually pay them the royalty, they pay you the royalty, taking a cut, of course. But it's a lot easier for you, okay? So that's another way. And another up-and-coming way, pioneered by my partner, Stanley Smith, at open access. Okay, similar, we were talking about open source, where artists would donate or put their work in the public domain. Okay, open access is the same thing. Museums, such as Getty, many others, I think Brooklyn does it, the Mauritius in, no, it's not, it's the Rijksmuseum in Amsterdam, all open source. And you go to their website, and it will say, here are all our works, all of them, at least all the ones in the public domain. Thousands of them, and they're high-res scans. And it actually says, take this work and copy it. Okay, make mugs, make T-shirts. We want to see what you do with. You don't pay us anything. We create, here's a high-res. We love that, right? We love that because we can go and do exactly, and it even says, you can do this for commercial use. It makes it very clear. This license is for all uses, including commercial. Okay, so that is open access. Okay, so all of these licensing, as you'll see, increase exposure, which is most of your mission is about getting your works out to the public. Licensing the images does that, okay? Secondarily, though, your mission can only be fulfilled better than me, okay? So licensing programs make you money, and we love it when we pay royalties to you guys, okay? We have paid close to $500,000 in royalties to you guys over the past 6 years. Okay, and we are incredibly happy about that. In fact, we're probably over $500,000 by now. Okay, program or using ours or using a third party, you can get a lot of money to fulfill your mission. Okay, but you got to do work. So some people fulfill their mission, some museums, by doing open access, because that is ultimately their mission, and in some ways that gets it out there even more, because it's sort of that explosion effect that I talked about, where you know, like when the Rijksmuseum went public with their open access, all the papers wrote it up, you know, hey, you can now go here and get these Rembrandts and do anything you want with them. You know, that caused, again, an explosion of creativity, okay? So there's a lot to be said for open access, but there's a lot to be said for more traditional licensing programs. Okay, well, now how do we make these products, you know, if the work is copyrighted, you know, say, and I want to make stuff for my gift shop, okay? How do I do it? Okay, you do it the same way as you do it for other products, that is your public domain works of art. And if you happen to own the copyright because it was deeded to you, for instance, those O'Keeffe's or something else, now it really is exactly the same. Okay, you know, someone else to make the reproductions for you. Okay, but if you don't own the copyright, now you have to, you or your publishing company, such as us, have to get permission to make the copyright of the work of art you own. And that is usually in the form of a license, which we just talked about. How do you get a license? Okay, usually that's up to the vendor, although you guys know, we'll talk about traveling exhibitions in a little bit, that sometimes licenses come to you, okay, with works of art or shows, or sometimes you as a store manager, you know, may be going out and making a lot of products, magnets and calendars and catalogs and prints, okay, through different vendors, okay, but instead of having all the different vendors get the copyright, you know, sometimes some of our museum part, we already went out and they show that to us, and then we don't have to get the copyright because they already have it. So that happens sometimes. Okay, so that's where you, and once in a while, it's pretty rare, but once in a while we find an estate, okay, that goes, no, we don't like you, big corporation in the sky. We will not work commercially at all. We're not going to give you a copyright. And we have to honor that. So they're right. Okay. But sometimes we say, well, how about if the museum did it? Oh, yeah, museum. We love museums. Okay. So then the museum has to go into more work and get the copyright through them. And the museum has to pay them the royalties, not through our program that we have already. So it's more work for the museum, but sometimes the artist or the artist's estate just doesn't want to work with a commercial company. So in that case, you, the museum, have to do more work. Okay, in all cases, one of the main things we found is you need time and you need flexibility, okay? So, and we're always trying to be proactive. We're always looking, especially at the special shows that are coming up. As we know, our museum partners are going to come to us like 3 weeks before the show. They actually gave us a lot of time, but it's just an example. And they're going to say, we want prints of all these Beardens. And we're going to say, you know, you're not going to have them in time, okay, because we know it's hard to get. And so we actually just cleared rights on the Bearden for the Frick show that started in April. So time, and we also say, we're going to try, this is your works of art in your production, in your collection, and also in traveling exhibitions in particular. So those are the ones that need more time, okay? Sometimes the shows come with the rights, at least for some things. And don't forget about your online store, right? We haven't really talked about your online store at all as part of this same deal, okay? You can't even put those little images up, you know, of copyrighted works of art unless you have you have rights to do that from the copyright holder. So sometimes special shows, all that comes in a package, right? Because you've probably paid for the whole show, so you get not only the works of art, but the copyrights. Sometimes it doesn't. Okay, so you got to watch that. Sometimes products from previous venues, and otherwise, you know, you're going to have to work with the vendor, get the license, and allow enough time. Okay, so that's like the core talk, but the futures, okay, and this is the question we get all the time: what the heck is an NFT, and why should I care? Okay, I'm sure you've seen this in the news with these astronomical, ridiculous, absurd sale prices for these things that you don't have a clue about. But you know that under all the talk, there's like some work of art under there. No one knows, okay, but I'll do my best. So it's a sort of a digital certificate of authenticity, okay? Not really, okay? But if you think of a certificate of authenticity, is it really a certificate of authenticity? It's really just a piece of paper that says it's a certificate. How is it really linked to the work of art? Same deal with an NFT. It can claim to be a certificate of authenticity, but especially because it's out there on the internet, you know, it makes it a little more dubious. It can convey the fact that you own a work of art, but it cannot convey that you own the copyright, or does not usually. Okay, so does that sound familiar? You own the work, you don't own the copyright. Okay, you own the NFT, you don't own the copyright. Okay, same deal. Okay, so if an NFT is saying, you know, you get the copyright, it's probably lying. You're going to have to really dig deep in that. So NFTs are a mess. They're very hard to create. They're very hard to understand, and they're of very limited use. And for those of you old enough to remember like the 90s, okay, 1990s, okay, that's what the internet was. That's what the World Wide Web, what was that, in the 80s and 90s? And, you know, there was no phones. You know, if we had a pandemic in the 80s, I don't know what would happen, okay? But so don't write off NFTs just because they're overhyped, overexpensive. They're going to crash. 2001, you may remember .coms. They all crashed. Okay, they all went, stocks went like this, and stocks went like that, which they're now doing again for different reasons. NFTs, you know, have been going like this. They're going to go like this, okay? But then they're ultimately going to come back. So very, very important. I believe, you know, looking at my crystal ball here, okay, that where NFTs are going to be particularly useful for you guys is in the metaverse, okay? Now, what's the metaverse, right? You've heard that one before, too. Facebook is now called Meta. Why? Because they're going to the metaverse. So this is that mythical, if you've seen Ready Player One, for instance, the mythical world where you live your life online, okay, and you reproduce your life online, except it's got magic behind it because now you can fly and stuff like that. So, but there's, you guys, so the next step, you have your websites already, right? You know, 20 years ago, you would have gone, what's a website? Why do I want one? Maybe 30, okay? Now you're going to have to start making your metaverse, right? You guys probably seen the crazy glasses like this where you don't have everyone's doing crazy things, right? That's the metaverse. And to be able to display works of art in the metaverse, like the authorized version, you know, so your Van Gogh that's on your wall, anyone can take that and put it on their metaverse right now, okay? If you want to limit that or at least authorize that, you're probably going to go together in the future. They're not there now. Another problem with NFTs is they're bought and sold through cryptocurrencies, okay? And you guys have heard about Bitcoin and all that, and again, ups and downs and crazy and thefts and not trackable and, so NFTs are bought through cryptocurrencies, making them even worse, okay? You can NFT, okay? Someday I think you're going to be able to. These have to get easier. The same way the web, right, didn't take off when everyone had to write, HTML, if you even know what that was, no one could do it. Very few people are doing NFTs because you got to be a nerd to do it. So, and you got to use cryptocurrencies and crazy things like that. An interesting sleeper feature of NFTs is artists can receive royalties on resale, okay? Right now, if you are an artist, current day artist, or Mr. Tebow or whatever, when he sold a work of art, he still had the copyright, okay? But he lost all resale rights on that. So he sold it to a private collector who sold it to another private collector, and now his estate, with the NFT, which could be the artist, gets the royalties. Okay, so that's the 5-minute version of what would take 2 years for anyone to actually understand. So to summarize, and then we can have additional questions, copyright is complicated. Okay, very simple statement. And we and others can help with that. So here's my contact information, and thank you very much. So people probably have some questions. I think there's a mic we want to pass around, although I can also repeat the question. So please go ahead. Maybe you can bring that to her back there.
Hi. Can I take this bottle of Perrier, paint it, and sell it on a note card?
Bottle Perrier, so again, not legal advice, but no, because Perrier has various, because they're a big company, right? So they have lawyers, okay, and they have trademarks probably on the name Perrier, and they may very well have copyright on the shape of the bottle, the color of the bottle. They may have a design patent, which is a different thing. So I'm pretty sure the answer to that is no, and they probably will sue you if you do that.
What if I photograph somebody in the park drinking out of a bottle of Perrier? Can I sell that on a note
So
card?
now you're getting closer to fair use, right? Because it's mainly the person holding it up. It's going to sort of depend. If it's mainly the bottle and just the person in the background, probably not. If it's mainly the person probably can't even read that it says Perrier, then probably yes. So again, it depends. It's complicated, but that's a really good example of things like that. So there was an NFT recently, I can't remember what it was, and it said, Olive Garden of all things, the restaurant, Olive Garden. Someone went around the U.S., why, don't ask me, okay, and they made NFTs to every single Olive Garden. And for like $39, this is why the market's so crazy, for $39 you could buy the NFT of your local Olive Garden and be the only one. Well, Olive Garden lawyers woke up and they sued the creator of the NFT. Not only they all go down, but everyone who bought them was invalidated. Okay, so all of a sudden you own an NFT to nothing. Okay, so that's a perfect example with Perrier. That if it's commercial, you probably can't copy it.
So an artist goes to the museum and paints an image of the outside of it and decides to donate it to the store. They leave and go to Europe. You try to reach them and they don't answer back.
Yikes.
Can you sell that?
Did they give the copyright to the museum when they did that?
It was just a donation. It was a painting. They were painting on a patio, and before they left, they gave it to somebody on the inside.
Right, so if it was informal, then I'd have to say no. That they certainly maintain the rights to that. If they didn't give it to the museum, then they maintain it. So a copyright thrown out with that copyright 76. Once you create a work, you own the copyright, and unless you do otherwise, you own the copyright, okay? And so no one can copy it, unless you specifically and explicitly say they can. Okay. So whether they went to Europe or not doesn't really matter, unless you can reach them and you can get them to say, yes, I give you permission or I deed you the copyright, then to be safe, no, you definitely shouldn't do that, in my opinion.
Okay.
What if the museum pays that person to paint it?
Okay, so now if it's work for hire and there's a contract And it says, usually any good contract will say, I'm paying you for this work for hire. Not only do I get the physical work, but I get all copyright, trademarks, and et cetera to it. And the contractor who did that signed, then you own the copyright as per the agreement, okay? And then you can do anything you want. So work for hire, very, very important. You don't just get the work, that you get the copyright, and most contracts you usually do.
What if the artist is an employee who was doing the assignment? So it's work, that's what I'm loud. It's work for hire by.
Almost all employee agreements, okay, say that any work product you create as part of your job is literally owned by us, the employer. So for instance, you get a patent, okay, this happens all the time. You're working on something, I actually did this when I was at Apple. I own like 7 or 10 patents, I lost track, but I could not make any money out of that because my employer, Apple, okay, got my work product as part of my employee agreement. So the cool thing is my name's on the patent, right? That's my patent, my name's on it, but all the rights are with the employer. And almost any employee agreement, even with the museum or whatever, is going to say, your work product done as part of your job, that's ours. We own it. We own the copyright, we own the work, everything. But that's a really good question.
Hi, I have a quick question. Well, I don't know. But I'm going back to the donation. We have a similar situation where we have a volunteer who's been, very generous with us, and she's a local folk artist who basically created and paint designs on ornaments. And we've been creating these ornaments where she gave us the art so that it can be put on the ornament, and then we sold it. And we're going on to like 5 or 6 years of this, and we're now kind of thinking like her age, and we're worried. We don't know what may happen to it, if the family may start, asking for it or for proceeds, but she never took the proceeds. It was all donated. Basically, all proceeds are going to the museum. So I was wondering if there would be a good.
One would be if she's still alive and you can contact her to absolutely do that, okay? And just say sort of what you just said, we think you meant for us to get all the revenue out of this, okay? And you can say our lawyers, or you can say some guy up front told me that you should have her formalize that. And she doesn't have to, from my perspective, she doesn't have to get a lawyer. You don't have to get a lawyer. Maybe you have a legal department, and she may be resistant to like signing this document, So it's sort of okay if she just sends you an email. At least you're going to have that. It's probably not ironclad, okay, but she's probably not going to sue you. And whether her estate sues you or not, I don't know. So, we often go off an email, that says, yeah, it's fine if you do that. Okay, better would be, give her a document and say, this is just going to cover, if you want our museum to thrive when you're gone, it would help us for you to sign this document. So it just sort of depends. Another legal concept I'm not that familiar with is, I don't even know what it's called, I'm so unfamiliar with it. Facto for a long time. Okay, then there's a legal precedent that says if it's always been that way, in lack of some other circumstance, it should be that way in the future. So you can sort of claim, she intended this. When she gave it to us, she said this, even if it's verbal. We've been doing it for years. She's known about. People can formalize that concept. That's a worst case, so it's obviously much better if you just get her to say, yeah, this is what I meant, and you should always get the revenue. Yeah, another good question. Couple in the back, lots in the back.
Hi, I had a little bit of a question about licensing. So my understanding at this point is that licensing is essentially a blessing or kind of a seal of approval from a foundation. For instance, I have a traveling exhibition that my museum will be working on for this October. And as far as the merchandise is concerned, we're contractually obligated to purchase from their licensed vendors first. And then we have an option to make our own merchandise as well, which is going to cost more as far as the contract is concerned. But we can't create any items that are already created by licensed vendors. So but however, I had noticed as I was doing my research for the exhibition that I was finding imagery from this artist, Alphonse Mucha, and other reputable vendors as well. So I was a little bit confused at that point. Well, what's the difference here? So essentially, the licensing is just their blessing, their seal of approval from, like, we.
Well, remember that it's a complicated thing, and MUCA actually has a foundation that tries to enforce all sorts of stuff, okay? And so he's with the foundation. He's also an overseas artist, making, I think it was Austria maybe, I'm not sure. Czech Republic. Oh, you guys are the art experts, not me. And so that makes it more complicated. And yes, and then it's an exhibit coming from them where they definitely have a lot of say in things. So it is, yeah. So you want to, it's public domain. For instance, we, reproduce, we've done a number of shows where we've reproduced it without talking to the foundation. We've never had any problems. But yeah, it wouldn't be the authorized, if it's from the foundation, you can actually say foundation approved, foundation authorized, things like that. So it is better and probably easier to do it that way, but you may have less flexibility and it may cost you more, and some of your vendors may be excluded. That's what we sort of hate, because it does happen where there's a show and the show creator says you can only print through this vendor, and our museum wants to print through us, but they can't. So we have to honor that, but we don't like it. And that's a copyright lawyer, are you saying?
She's a copyright and music lawyer.
Uh-huh.
Her name's Paula Geddert, Goedert. Endorsed by the MSA for a long time.
Great resource to know about. Yep, two more back there.
Thank you. How does copyright work with the image of a person, such as RBG? Etsy, people use her image, or they'll paint, folk art of her image. How does that work with copyright?
So questions about images per se, images of people in particular, I'm not that familiar with in terms of the ability to control your image, okay? And you may know, for instance, the NCAAs of student athletes. So that's a good question, but what I do know is images of articles, for instance, or other corporate creations. So, for instance, we were asked to reproduce, it's not a Bearden work, I'm not remembering the artist, Mickey Mouse Runaway, okay, because that's Disney, they have too many lawyers, okay, and they control, although it's Mickey Mouse is finally getting into the public domain after that, as I mentioned, the Sonny Bono Mickey Mouse Act, Disney lobbied Sonny to, anyway, so that's a problem. I've always wondered, things that Andy Warhol, Campbell Soups, did he get the rights to do that? I don't even know. Okay, but it's asking for trouble. But I don't know about, and so Kahlo is really interesting, her husband Diego Rivera as well. Okay, that's another example of a very free licensing policy and how successful it's been. So those works are under copyright, but both the likenesses and the works, including all her self-portrait. You got to license them, but the license is very free. You can go to it's Artist Rights Society, you may know about them, and you can get a license very easily. You do have to pay royalties, but they're not, unlike some Frank Stella, for instance, can't license, okay? But Kahlo, Rivera, oh yeah, you can license for anything you want. You got to pay us, okay? But again, and they've been really, really successful because of that policy. So you do see Kahlo all over, because one, she's cool and popular, but three, she has her estate has a very broad and liberal licensing policy.
And like with RBG, she's
Yeah, I think you're right about the public figure thing. I think that's true. Okay, was there another question in the back? Yeah, right back there.
Hi, I have a question and a comment. A comment on the image of the person, the famous person. It's known as, maybe you've heard this expression, it's sort of quasi-copyright. So whoever takes that picture of the famous person, that's the author, right?
Yep.
Photographer, right?
Yep.
Photography was recognized as expression, and so the copyright's with the photographer. But then if the person is famous, they have a right to benefit from their famousness. And so that's dealt with under different places, call it different things. the right of privacy or the right of publicity, right?
Priscilla Presley pioneered this with Elvis.
Right, so there's 3 jurisdictions that really have good laws on this. You can guess where they are, right? They're New York, California, and Tennessee because of Elvis.
Okay.
My question is on the situation where what should institutions do where the copyright term hasn't expired, but maybe the artist has passed away, but the 70 years, life plus 70, and you don't know where that person is, so it falls into this category of orphan works. Do you walk away from it, or how would you recommend these folks deal with those images?
Now, that is a really good question. So there is a category in the copyright law called orphaned works, okay? And that applies generally when a creator has passed away without a will, okay? Or otherwise the information, the history is lost, okay? Orphaned works are essentially orphaned, okay? But you are taking on some additional risk if, for instance, a legal claim were to be made, okay, then there'd have to be a lot of research. So the classic example here is the amazing artist Alma Thomas, okay? And we've done a lot of work on this because we love Alma Thomas. In fact, a work by Alma Thomas, come by 418, paid political announcement. And we have done a massive amount of research, okay, to try and find a copyright holder, not just us, many, many museums, the Brooklyn Museum and others, okay? I actually talked on the only direct living relative of Alma Thomas, okay? And he said something to the effect of, no, I don't have the rights, I don't know who does, no one does, you can do anything you want with it. So you want to do a lot of research, in that case, and document it, wait, maybe their claim is legit, okay, in which case you have to start paying them copyright, but they can't go back, I don't think, and sue you because you've done your homework and they were like, in the shadows. So be careful with orphan works, but don't run away from them. They're important works of art and want them to be available to the public. They might have wanted some of their heirs to benefit, in which case they should have had a will, but that's why we ran towards Alma Thomas, even though it took a lot of work, and we're very, very happy we did. She's got a great show at the Columbus Museum in Georgia. I don't know if anyone's from there. Mend it. Okay, so I think we've gone over time, so thank you again.